Hi, good morning, everybody. I'm Catherine Byers, and Allison, I think at this time I can share my screen. Is that right?
Yeah.
Okay. So I'm gonna share my screen, and we're gonna start the presentation here. As she said, I work for Weisinger Law Firm. We focus primarily on estate planning. We do also practice probate and guardianship law. But for today's purposes, excuse me, we're going to really focus on the estate planning side of things, and particularly how we can use estate planning to fund these special needs trusts. So we're just going to kind of jump right into it. I usually like to start my presentations on just an explanation of what I mean by an estate plan. Because when I say that term, most times people are going to jump to this idea of a will or a trust. Having some type of plan in place that says, when I pass away, here's who gets my stuff, and here's how they're going to receive it, which of course is a huge part of any estate plan. But the other side of an estate plan is also making sure that we have something in place for us while we are still living. It's to plan for the time of the in-between, between now and whenever we do ultimately pass away. Because the goal, of course, is to live for as long as possible. But the longer that we live, the odds are that we might encounter some type of an emergency situation. You know, we may get sick, we may develop Alzheimer's or dementia. So it's just as important to have a plan in place for you right now as it is for making sure we have something set up for when we pass away. So, and the best thing here is that you get to decide. You don't leave it up to chance. So I'm not going to spend too much time on these. In the past, we've kind of delved more into these, but I really want to focus more on the will and funding these trusts. But just for everyone's education and for their knowledge, these are the key documents I would recommend for everybody to have. Sometimes people think that in order to have an estate plan, you have to have a lot of wealth or money. And I say it doesn't matter how much you have. I would tell the person who has $100 million the same thing that I would for someone who has maybe $10 in the bank. These are key documents you all need. A durable power of attorney allows you to name somebody to help you make your financial decisions if you ever can't do so for yourself. A medical power of attorney says, here's who I trust to make my medical decisions if I can't for myself. HIPAA is the federal law that protects all of our healthcare information. And we want to make sure we have a release so that those doctors, nurses, those staff that are dealing with our healthcare information can release it to our loved ones if for any reason we are in that situation, we're in a hospital. A guardian, declaration of guardian, allows you to name somebody to take care of you if you ever become incapacitated. The appointment of guardian for children, that's where you can name someone to take care of your minor children if something were to happen to you. And the directive is where you can direct whether or not you would want life-sustaining treatment to be continued if you were in a vegetative state and you were not expected to come out of it. So again, just for brief information and knowledge, I wanted you guys to have that, but I don't want to spend too much time on those. If you ever need some information on that or are curious, you can always come see us or contact me after. So let's get more into what I want to talk about, which is the will. I could probably spend a whole presentation on why wills are so important. Practicing probate law, selfishly speaking, I tell my clients all the time, it's as much for me for after you pass as it is for your loved ones. Wills are crucial because they contain a roadmap for our loved ones after we die. And again, if we don't have that roadmap, if we don't tell people, when I die, here's who's in charge, here's who gets my stuff, and here's how they get it, we leave it up to chance. And that can leave a lot of people with different interests who think maybe they're better qualified to serve. They can really start fighting and wasting a lot of those assets. If you don't have a plan, then we spend a lot of time and money trying to figure that out. So that's just a basic intro of what a will is. It can contain a lot of different provisions. It can name guardians for your minor children if you so choose, if we don't have a separate document. And one thing I like to really point out too is that wills don't have any power or effect until they've gone into a court. It's called admitting a will for probate. Sometimes that term probate kind of scares people. They don't know what that means. And really all it is taking a will, presenting it before a judge, and the judge says, yes, we're going to honor the provisions here because it's a valid legal document. So again, getting into why you need a will. In Texas, if you pass away with a will, you are considered to have died testate. Versus if you die without a will, it's called dying intestate. And for purposes of today's talk, if someone passes away without a will, the state of Texas will determine what happens with your assets and who is supposed to inherit them. And a lot of times, our children are named as our heirs to our estate. And if you have a child who is receiving government benefits, who all of a sudden has now inherited a large chunk of your estate, and that could potentially be devastating for them. They could be kicked off those benefits. So why it's so important to have a will for today's talk is making sure we have a plan that will allow your loved ones to protect those government benefits. So when I talk about benefits, primarily I'm speaking about your SSI and your Medicaid. So SSI means Supplemental Security Income, and it's really a program for the quote unquote needy individual or a disabled individual. And when I say needy, I'm talking about someone who doesn't have money, they don't have wealth, they don't have assets or an estate. And particularly the key definition here is that they also have to be considered disabled. So for an individual to be considered disabled, Social Security defines it as someone who has some kind of physical or mental impairment that prevents them from having substantial gainful activity. What that really means is that they have something that prevents them from having a regular 9-to-5 job, working 40 hours a week, and having that source of steady income. It's a little bit different if you have a child. The definitions are slightly different. Just for purposes of information, I've included that definition here. For a child, they have to have a medically determinable impairment that causes marked severe functional limitations. And as a good rule of thumb here in Texas, if you qualify for SSI, then you're generally going to qualify for Medicaid. So SSI is there to produce additional income. Medicaid is more along the lines of the healthcare and the health insurance. And again, it's for those people who just can't hold a regular job. If I'm able to go into work, I can pay into the system. My employer typically has healthcare for me. Someone that can't keep those types of jobs or can't have that gainful employment, that would be denied to them. So the government comes in and says, if you qualify, we're going to give you a steady source of income, and we're also going to provide for your healthcare. So, well, again, when we're talking about your SSI, to qualify, you have to meet this definition. You have to be a needy individual, which means you have to have limited income and resources. Generally, that means you can't have more than $2,000 to your name. There are some exceptions. For instance, someone can own a home and that would not qualify as an asset. They can own a car and that would not qualify as an asset. But as far as income and money that they have in the bank, it can't ever go above $2,000. And if you can meet this definition, then again, you can get an SSI payment. And the maximum amount this year in 2020 was $783. In 2019, it was $779. So every year they adjust that amount, whether it's to adjust for inflation or cost of living expenses, but that number kind of goes up every year. And some people ask me, well, why are we trying so hard to preserve these, right? That's not a whole lot of money coming in. But the key reason why it's so important is because it's covering the basics. It's making sure that our loved ones have the things that some of us take for granted. $783 could be the difference for someone to make sure that they have a place over their head, a roof over their head, to make sure that they have food, the clothing, the shelter. Now, benefits can be at or below poverty level, but again, in a case where someone just can't hold a regular job, then this is key for them. This is their lifeline. So we want to work really hard to preserve these benefits as best we can. Also, if anyone has gone through that application process, you know how grueling it can be. There can be long wait lines. It can be a long delay before someone can get these benefits. So if we work so hard to get these benefits for our loved ones, then we want to do everything possible to preserve that. Some of the downsides of this, of course, is it doesn't cover pretty much everything else, right? It covers those basics, those needs that we all need. But for instance, if there's extraordinary medical expenses, if there's trips to visit relatives, vacations, those things are not covered. Transportation is not covered. Rehabilitation or athletic training. Sometimes you have individuals who have a very specific dietary need that they have, that's not going to be covered. So we want to find a way to make these two ideas work together. We want to make sure we're keeping these benefits, but also try to find a way to make sure we're providing everything else for our children as well. So a lot of times I have clients who come in and they sit down with me, and a lot they want to be able to treat their children equally when they pass away. They want to make sure that their estate goes 50-50, or how many, depending on how many children you have. But that can be very difficult if one child is receiving benefits and the other is not. So let's just take an example here. Let's say you have an estate that's worth $500,000. And they come down to see me and they say, well, I want to leave half to each child. I've got 2 kids. I've got Jim and Joe. But Joe is receiving SSI and Medicaid. If we don't put anything in place and I just let her split the estate 50-50, well, when she passes and Jim gets his $250,000 of inheritance, he can do pretty much whatever he wants. He can go on vacation. He can pay off debts. He can use that inheritance to potentially put money into a college fund for his kids, right? He's not going to be impacted in any way. However, if Joe receives this money, going back to those limitations that someone has to meet to keep their SSI, he's going to be way over that $2,000 limitation that he would need to keep the government benefits. So he might be excited at first. He's like, man, I have $250,000. But if you have someone who has special needs, they have a disability, we know that that's not going to last very long. We're going to spend a lot of that and it's going to be dwindled very quickly. So he's going to be happy at first, but he's going to drain all of his inheritance taking care of himself. So what do we do? What are our options? And I see this a lot. Parents, when they first come to sit down and meet with me, they say, well, what we're going to do is we're just going to leave everything to the other child. We trust that child. We know they're going to take care of their brother or their sister. And that way we preserve, making sure our child keeps those benefits. And it does sound very simple, but there's a lot of things that could go wrong with that plan. Primarily, if Jim receives all of that money, it's his $500,000 now. He can do whatever he wants with it. We hope he's going to be a good son. We hope he's going to honor your wishes. And even if he is that good of a person, what happens now if he gets in the middle of a lawsuit, right? Those attorneys are going to see he's got $500,000 in the bank. We can go after that. What if he has creditors out there and they've been waiting for him to get his inheritance and now there's a reason for them to go after him? What if Jim gets married, right, and then becomes divorced, and those funds can get wrapped up in those proceedings? They could have potentially been commingled with the spouse's their joint accounts. What if Jim now passes away and he doesn't have a will, right? His estate would now control what happens with that money. One thing I see a lot of the time, which is really, I see more often than not, which it pains me to say, but what if Jim he's just going to keep that money? What if he decides, hey, I really like having $500,000 in the bank. My brother Joe is getting his benefits. He's provided for. He doesn't actually need this stuff. When people get that inheritance, they can change very, very quickly. So, what are our options here, right? Do we leave all of the assets we want to our child, kick them off those benefits? Do we disinherit them? Do we leave them to somebody else? And that's where these special needs trusts come into play. So they're a very special type of trust. They can also be called a supplemental needs trust, and they are different from just a very typical regular trust. I have clients who come to see me and they will tell me, well, we had this other attorney draw up this trust agreement and they said it's a special needs trust. And when I'm looking through it, I will tell them, this does not meet the qualifications of being this type of trust. You want to be very careful when you go sit down with an attorney to make sure that they do have experience in this, because they have very special rules, they have very unique requirements, and very key language we need to make sure that are included in these documents here. But the reason why they work is because essentially we're taking assets and we're putting them into this sheltered trust, and the child who's the beneficiary of that trust never has direct access to it. Those funds are not readily available to them. And because of that, the government says, well, it's actually not their money. It's not their income. It's mom or dad's income that they've set aside for their child. And because of that, it's never seen as a resource, and it doesn't impact that $2,000 limitation that they always need to kind of maintain. And it will last for the child's lifetime. So as long as that child is living and this trust is around, they can always keep those benefits. So there are different types of special needs trust, and I usually like to separate them into when we can create them. You can create a special needs trust now while you're living or while your child is living, or you can create it when you pass away. But there are three key types of trust. The first one is known as a self-settled D4A trust. There is a pooled trust, which is what the ARC of Texas is, and we'll kind of get into all of these. And then the one that we most like to prepare and plan for and do for our clients is a third-party trust. So getting into the self-settled D4A trust. I like to start off with this one because I just spent the first half of this presentation talking about we always want to make sure we don't leave inheritance or money outright to an individual because they could lose their benefits. And I don't do that to scare anybody. I do that just so we can really stress upon you the importance of planning. However, if something like that happens, and maybe it's not even for lack of planning on your part. Maybe you have a relative who's passed away without a will, and now by some reason of our intestacy rules, you have a child who's inheriting assets. I tend to see that the most often. Now, this is a tool that we can utilize that says, yes, they've inherited property, but we are going to shelter it and put it into this type of trust. And so it's called self-settled because it's money that the child has inherited or earned directly to them. It's not money that's been given by a third party. And so if they get that money to them, we put it into this type of trust. It is only available to disabled individuals if they're under the age of 65. It can be set up by the individual themselves, by a parent or a guardian, or even a court. And the reason why I've underlined individual here is because that's a recent change in the law. It used to be that only a parent or a guardian or a court could do so, and it just didn't make sense. You know, sometimes you have an individual who is very high functioning, and they would receive inheritance or a lawsuit earnings, just as an example, and they couldn't set this up for themselves. So that's a new change in the law. But you'll see here that if they have inheritance, maybe they got proceeds from a lawsuit, those are the funds we're going to use to put into this type of trust. Now, the one drawback of this is that it has to have what we call a payback provision. And that just means that the government is going to be able to come back and make a claim against this type of trust when that individual passes away. And I'll get into this a little bit more and kind of give you guys an example. So let's just say you have this individual, let's just call her Sally. Sally is receiving her government benefits. She is very good at keeping her $2,000 resource limitation intact. But now, through no fault of her own, now let's just say she's inherited property. I have a real life case like this right now where I have a child who's receiving her SSI, and her grandfather passed away without a will. Now, her father would be the one who would typically inherit it, but her father had also passed away without a will. So by these default rules, we have this child now who's receiving a large chunk of cash. So nothing that she did wrong, nothing that her mother did wrong. It's just someone else didn't put these things in place. So now, through no fault of her own, she's got this large inheritance coming her way. And if she just kept it for herself, she would be cut off of those benefits. So what she can do now is she can come to me, or her mother, her guardian, whoever could come to me, and we would create this self-settled D4A trust. And all this type of trust is first and foremost, you have to name a trustee. A trustee is going to be a third party who cannot be that individual who's receiving the government benefits, and they're going to manage the trust. And they are going to manage the trust for a beneficiary who is going to be that child or that individual who is receiving the SSI or the Medicaid. So we create this trust. We have our key language for these trusts. These trusts always have to have some type of language that says it is here to supplement the government benefits. It's not here to supplant them. Meaning everything SSI and Medicaid is doing and covering, they should continue to pay for. But we want to be able to ensure that we can use these additional funds to pay for those extras. So then we take that inheritance, the lawsuit, whatever kind of money it might have been that this individual has now inherited, and we place it into this trust. And when you fund this trust, again, now this child or this individual has no control over it. They have gifted it away. They've relinquished it to the trustee. And this, again, stays in place for life. And so because we've distanced this child or this individual from these funds, the government says, okay, they no longer have $250,000 available to them. We're going to let them keep their benefits. But when this child passes away and this trust terminates, then you have what's called a MERP claim. It's a Medicaid Estate Recovery Program. And this is where you're going to see the government try to come back and make a claim against any trust property that may still be in here, or any money that may still be left in there. And the best way I can explain this, and I usually tell my clients this, is the government almost sees this as a way of cheating the system. They look at this and they say, well, this child actually has money that they should be using to pay for the things that we're paying, right? They have money to provide for their food, their clothing, their shelter, even maybe get their own health insurance. But the government also understands that, again, even if you have a nice chunk of cash, that could easily be gone in a year or two. So rather than kicking people off their benefits and then making them reapply, which again can be a very grueling task, they're going to allow you to keep those benefits while that child is living. But then they say, we get to come back first and try to get repaid what you should have been paying for all along. So it's a really good option, and it's a great tool to have kind of as just a backup tool if your child or loved one ever encounters this type of situation. So the next type of trust we have is what's called a pooled trust. This one has a little more, it's kind of a hybrid between a self-settled potentially and the third party. So it can be either one. And the nice thing about this is that it's available to individuals of all ages. So if someone is over the age of 65 when this happens, then this is still a good option to use to say we still have something as a backup in our arsenal to ensure we can keep our government benefits. Now, depending on what type of money we are using to fund this trust, whether it's our own money that we've inherited or it's a grandparent or a loved one who wants to leave money for us, that will trigger whether or not we have that payback provision. If it's money I've earned or I've inherited, then it will have this kind of payback provision to the government. If it's something that my parents have left me, then they can determine what they want to do with it. A lot of times what you'll see with these pool trusts is that when your special needs trust terminates, the funds go back to the other sub-accounts. So a master pool trust is you've got one big, same thing, you have a trustee who manages it. In Texas, the ARC of Texas is the manager for these trusts. And you have a sub-account within this pooled trust. So it's made up of a bunch of different smaller trusts that everyone can kind of build into as far as creating one big master pooled trust. And so it works the same way. We have a trustee, you have your beneficiary. We include that same language of supplementing, not supplanting those government benefits. And then we can take that money, whether it's money you've inherited as a result of someone passing away without a will, whether it's lawsuit, whether it's your parents' money, then you can put it into this trust. Works the same way. Child can keep their benefits for lifetime, and then when they pass, that money will either go back to the state if it's money that the child inherited directly, or to the other sub-accounts that this master pool trust is managing. The last one I have here is called a third-party trust. This is the one we work the most with because people that are coming to see us are putting their estate plan in place. And the most common way I see a third-party trust is we created this part of their plan when they pass away. So when we get to that, going back to the wills and why they're so important, a parent can say, I want to leave my estate to both of my children 50-50, going back to Joe and Jim. Jim can get his inheritance outright, but Joe, his one half of my estate needs to go into a special needs trust. And when you pass, then half that estate will be used to fund and create that trust for Joe. So it's just like it sounds. It's a trust that's created by a third party. It's funds from a third party. It's never money that was directly inherited by that individual. And you can create them. You could create one right now. You can do them during life, and you can also create them at death. Sometimes people want to have these trusts already created. That way, if they do have loved ones that want to provide for that child, they can say, hey, as part of your own plan, make sure you name this special needs trust as the beneficiary, for my child. Or probably most common is funding it when you pass away. Because some people don't necessarily have a lot of liquidity in their estate to fund these trusts right away. It's easier to have more assets to your estate when you pass to fund these trusts. So best thing about these, there is no payback provision because it's never seen as money that the child has earned for themselves. So it's set up the exact same way. We have a trustee who's a third party. They manage the trust. We identify the individual who is receiving those government benefits as the beneficiary of that trust. We fund this either, right now or either as part of our estate. We keep that key language in there that these funds are used to supplement the government benefits, not supplant them. And then we put the money in here, and the child then, again, can use these trust funds to pay for the things that the government is not paying for. Best thing lasts for their lifetime. It will terminate when that individual passes away, and then you get to decide where that money goes. So a lot of times when I sit down with parents, they want to leave all of their estate to this one child who has special needs. But they say, hey, when this child passes, if there's anything left, then those assets can go to my other children, right? So you get to direct where it goes. The government cannot come back and try to claim this because it's always the parent's money and not the child's. So there's different trusts for different scenarios. Trusts are a great thing to plan for. Some people ask me, so what are the downfalls of these special needs trusts? Primarily, I say you want to always be careful about the things that you pay for from this trust. So I tell people a good rule of thumb, if SSI and Medicaid can cover that expense, then you should let them cover it. Because if you start using those trust funds for the things that the government is already paying for, then they have cause to turn around and limit or reduce how much SSI they are giving to your child. So should not go towards things like food, clothing, or shelter. That's what the supplemental security income is for. And again, if you make certain distributions to cover for those things, then they can turn around and reduce that amount, that $783 that your child is getting. They can reduce that dollar for dollar. But the beauty of the special needs trust, of what it can pay for, is everything else. All of those other things we talked about at the very beginning of what SSI can cover and what it cannot. This is where the special needs trust comes in, right? We can pay for cars. We can pay for vacations. We can pay for advanced medical training. We can pay for vocational or educational training. So it's just there to ensure that your child, yes, they're getting the basics to ensure they get by day to day, but this is making them have a better quality of life. So how do we plan with these? Most importantly, how do we fund these trusts? And this is really where Miguel and his team are going to come in. There are all sorts of ways in which we can fund these trusts to ensure that our child or our loved ones have ample resources during their lifetime. One of the most popular ways that we see is using life insurance. And again, I'm going to let Miguel get more into this. But if you purchase a life insurance policy, you can name a special needs trust as that beneficiary. Sometimes I joke I'm probably worth more dead than I am alive. I have we've got life insurance. It's a very cheap way to ensure that if something were to happen to me, my loved ones have ample resources after I'm gone to take care of themselves. So life insurance is a great tool. We can also look at possible inheritance from other parties. So if you have grandparents who want to get rid of some of the property in their estate, they can leave assets to a special needs trust. And another one I see a lot of here in San Antonio, because we are such a big military town, is the Survivors Military Benefits Plan. You can name a child who is receiving SSI or Medicaid, or a child who's disabled, as a beneficiary for these benefits when you pass away, if you are a member of the military. One thing I try to stress, though, is when you name your child as a beneficiary on those plans, it's a great thing. They've got extra income coming to them, but that's money that the child is receiving for themselves. It's their money. So if that benefit that you want to leave for them increases how much money they have, if that puts them over that $2,000 limitation, that can impact their SSI. So you would want to create a self-settled D4A trust right now that says, when I pass, these military benefits will go into this trust for my child. So that way they can keep their SSI and your military benefit plans and not have any kind of lapse in the coverage here. So what should we do? What are your important steps to take next? I always tell my clients, get your team together. Right, it's not just me. It's a united front. I mean, I specialize in the special needs trust. I can do the estate planning part, but you need to get with Miguel and his team to figure out how to properly fund these trusts. You should have a CPA, someone who knows how to file taxes for these special needs trusts and to take the certain deductions and other things that you want for these trusts to benefit from. Talk to an estate planning attorney who has experience with these special needs trusts. Sometimes these attorneys think it's very easy to put these together. And when I'm reviewing these, I have to tell these clients, this is not a good trust, right? You want to make sure you have the right people doing these things for you. Definitely talk to your CPA. Get with the ARC here in San Antonio. Talk about all the available programs that your child can invest in and benefit from. Make sure you have someone in place. One of the biggest things clients ask me about is, well, who's going to take care of my child when I pass? That's always one of their biggest concerns, right? Start thinking about that now. Who do you trust to take care of the child the way you are right now when you're gone? I think preparing a letter of intent, I don't know if that's a term most people know or don't know, but what a letter of intent does, it lays out instructions for the next caretaker for your child. The nice thing with this is that nobody knows your child the way that you do, right? It's very easy for me to step back and say, well, I can make sure that the child's not going to lose their benefits, and all these things, but I don't know what your child's favorite TV shows are. I don't know what kind of cereal he likes or she likes. Those intricacies that make your child unique and the things they like and don't like, put that in a letter of intent. Make sure that the next person in line knows the inner workings of your child just as well as you do. And then, of course, get a plan done, right? Get something done with special needs language in there. That's the best thing you probably can do here. And then, of course, if you have any questions, we're always free to talk. We always offer free consultations for our clients and potential clients. Primarily, we want you to have the information and the education. So that is all I have as far as my presentation is concerned. I'll stop sharing my screen now. And Allison, are we doing questions now or at the end of everything?
We'll do them at the end.
Okay. So that's all I have, and I guess now I will pass this over to Miguel.
Awesome. Okay, so let me just get this thing fired up properly. Slideshow, and let me share this. All right. Okay. Well, thanks a bunch, Catherine. Good morning, everyone. Miguel Velasco here. Really looking forward to the time. That's a great foundation for this next part of our conversation, which is really funding the special needs trust. Before I get into that, I am a fully licensed financial advisor. That being said, a couple disclosures. I'm not a CPA. I'm not an attorney. The attorney that prepares the legal documents, that's Catherine, who you just spoke to. And that CPA is that other person that is integral in terms of your of putting together your team. So what I'm going to focus on today is two fundamental questions that really come up as we go through this. It's how much do I need in a special needs trust to make sure that I take care of my loved ones? And then how do I do it? So we're really going to walk through both of those right now. So the first thing, how much do you need? How much is needed in a special needs trust? The first thing is you want to determine what that quality of life is going to look like should you no longer be here. So that's residential, educational, medical, any of those needs that you're wanting to ensure happen when you're no longer with us. We want to also take into account the cost of some of those needs and the rising costs, so we can assess what they are today, but also take it into account what they might be in 10 years, 20 years, or 30 years out. And then lastly, whether we're receiving benefits or we're in a position where we'll likely receive benefits, just taking that into account. So really an assessment of current and future benefits. Next question is for how long? So, there's two approaches that I share with clients. Essentially what you're doing here is you're funding this special needs trust, then you have to determine how much is in there and how you're going to start drawing that money out. This special needs trust, as Catherine said, is meant to supplement. So you can use it on an as needed basis. So they might just be one-offs that happen throughout the year, or it might be something that we're going to consistently draw from. So the first approach is just that, where we spend it down. Hard to nail down the exact number that needs to be in there. I'll give you guys a couple ideas shortly, but it's saying, hey, I'm going to leave this set amount to be used as needed. And the intent is to spend down that account. Should there be a remaining portion, you're able to name beneficiaries, whether that be brothers and sisters of that individual or other loved ones. And this is talking about the third party trust that Catherine spoke about. The other approach is an interest approach. This is much more like retirement planning. So when we're saving for retirement, just to keep it simple, if we accumulate a certain amount of money while we're working, once we transition to retirement, the College of Financial Planning recommends that we draw between 4 to 5%, 5% on the high end of that account on an annual basis. The reason the recommendation is 4 to 5% is so that you're really just drawing on the interest and not bringing down the principal. So you're able to live off of that interest and not tap into that big pot of money that's generating the income. So this is a much more conservative way to do it, because when we take this approach, we're really eliminating the what if I run out of money. But we're going to have to accumulate a higher dollar amount to be able to generate enough interest to meet those needs. So I'll walk through a few examples here. How do I fund it? Catherine spoke about this in Okay, let me just adjust here, guys, because I've got something that's blocking my presentation. Okay, here we go. How do I fund it? Before I get into exactly a couple strategies to do it, I just have to reiterate the beneficiary conversation. It is critical that you go back and review any type of account that has a beneficiary. This is going to be IRAs, 401ks, 403bs, 457 plans, TSP, thrift saving plans. These are all types of retirement plans that are available based on your employer. You absolutely want to go back and make sure that you update those primary beneficiaries while also adding contingent beneficiaries. That's something that's very, very critical in a planning piece that a lot of people miss out on, quite frankly. They'll name a beneficiary on their 401k when they started working at Valero 15 years ago and they were single and they named their mom or their dad or their brother. Then life happens, an individual gets married, has kids, so on and so forth, and that beneficiary never got updated, or maybe has never been updated from a spouse. So there's a lot of ways that not having updated beneficiaries can come to fruition. I really want to encourage, go back, review all primary beneficiaries, and add contingent. This also applies to your annuities, your pension, any life insurance programs that are held through work or outside of work. And I think Catherine would probably agree with me, don't lean on just the will. Some of these accounts are contracts, and so the beneficiary that you name in that account is what's going to happen. And so you just want to make sure that your will matches up with the beneficiaries you have listed. Very, very important. So 3 funding strategies that she touched on briefly. I'll elaborate a little bit more. We can either gift existing assets, we can fund ourselves, or we can use life insurance benefits. So when we fund through gifting, here we just want to identify all the assets that could be used. So this is going to be a review of, parents or caretakers' assets, grandparents and other relatives. Very much do we see a family approach.
It looks like you froze, Miguel. Oh dear. Let's give him a second to log back in. Okay, it looks like he's getting back on, so we'll get started again in a moment. Sorry about that, everyone. Okay, he's back. Let me just make you a co-host again so you can share.
Yeah, so I don't know what happened there.
That's okay. Okay, you've got the privilege of sharing again, so go
Okay.
for it.
Yeah, let me share here. All right, I think we're back.
Yeah, we're good.
My apologies. Okay, so funding. You know, I was just mentioning to create awareness. Create awareness around family members who are involved and are potentially assigning beneficiaries that are outside of that household for that special need, that special needs loved one. You know, they have good intent. However, with that good intent, if it's not communicated, you know, it could be detrimental. It could be that they're leaving those assets just in their name and they'll disqualify them from some of those benefits. So creating awareness around the team to update beneficiaries if there are going to be some gifting opportunities here. Next way that we can do is, well, not next, the pros and cons of gifting is that perhaps the wealth already exists and there's no funding cost per se. But the downside of that is that we may lose control of we will lose control of those assets. If we overcommit and something unexpected happens, have you left yourself in a position where now you don't have enough to meet your own personal planning needs, or just considering other children that may be involved? Funding through personal savings. So this is saying, okay, we've come up with a budget. We can set aside a certain dollar amount on a monthly basis in order to generate that lump sum that we're going to leave in the special needs trust. So very easy scenario here. Mom and dad, just simple math, they're 35. They have a son with autism. The goal is to leave a special needs trust through contributions. The goal is to accumulate $250,000 by age 60. So 25 years to go. Basically what we do is we say, okay, if we're assuming a 6% growth on that money, it's going to take us about $360 per month over the next 25 years to accumulate $250,000. This is no different than a retirement planning goal of someone saying, I need $500,000 or $1 million in a retirement account so that I can be able to retire and maintain my standard of living. It's the same way that we plan for that, just with a different purpose. So this is what we would do if we're funding through personal savings. Once that money, I will share, when that money is in that special needs trust, this money can be invested in a variety of different ways. And that's where working with a fully licensed financial advisor, I believe, is critical, so that all the options in terms of growth are on the table and you're not just being sold a product or are limited in what you're being offered. So I just really, really want to stress that part. And I'll talk a little bit more about a resource that is helpful in identifying fully licensed financial advisors. And then funding through life insurance. So, you know, this is a part that I think is really important from an educational standpoint, because most people, when I ask them, what do you know about life insurance? Overwhelmingly, the answer is, well, there's term and there's whole life. And this is where I just have to pump the brakes and say we have to recalibrate that and just really understand that there's term and there's permanent insurance. So I'll talk a little bit about each. Term insurance is a very, very inexpensive way to cover the need. It's like renting the coverage, is what I compare it to. It's like renting an apartment. After that time, you never really own the property, but you had a roof over your head. It does cover you for a definite period of time. It could be a term 10, term 15, term 20. The amount of coverage, the death benefit, stays level, stays the same, as do the premiums. So what you're paying on a monthly basis. So really, you're just paying for protection, just the cost of insurance. So insurance companies will say, okay, I've got a 40-year-old. What are the odds that something happens to them if they take out a term 20? What are the odds that something happens to them from age 40 to age 60, assuming their health? And they'll say slim to none. Yeah, we'll offer them $250,000, $500,000 worth of coverage for a very inexpensive dollar amount, $50 a month, sometimes less, sometimes a little bit more. You know, what I do want to stress here is that we cannot rely on just our work coverage, our group coverage, if this is going to be one of the strategies, because the minute we leave that employer, we'll lose the coverage. Or if we're able to then personally own it, it might just be a lot more expensive because now we're older, maybe our health isn't the same. So if we don't have coverage outside of work, term is an excellent place to start because it'll help you place the appropriate amount of coverage for a very, very inexpensive monthly commitment. Then there's permanent insurance. I describe this much more like having a mortgage. You know, here you're buying a house because the intent is that you're going to keep this policy and it will expire when that individual passes away. So it's intended to last through age 100 plus. The death benefit, the amount of coverage can be the same or it can actually increase over time. The premiums are flexible. So what I mean by that is there is an opportunity for you to, if an emergency comes up or we get laid off or something like that happens, you actually have the ability to stop paying into the policy but not lose the coverage. That's very different than term, where if we don't pay, we might have a grace period, but after that grace period, we don't pay, we're going to lose that coverage, just like your car insurance or your home insurances. Permanent insurance, the reason, and one of the designs that's really important here is this cash value part. Now, I want to be perfectly clear when I talk about the cash value. Insurance is insurance, investments are investments. This is where a lot of people try and do too much, or I believe are sold a product versus are just given advice. To me, in our approach, when we're looking at permanent insurance, is not to use this cash value to supplement your retirement while at the same time putting the coverage in place. Everyone's heard of those types of approaches, and a lot of people have been burned by that approach. I like to think of this cash value much more of like a gas tank. And the whole goal is to fill up that gas tank, because if you can accumulate enough cash value, you can actually stop paying the premiums. You no longer have to pay those premiums, and now there's enough gas in the tank, there's enough cash value to pay for the policy itself. Some people will have these policies paid up in as quick as 10 years. Some might take a little bit longer. The takeaway, though, is that cash value is meant to allow you to eliminate that payment, but keep that coverage in place. One is not better than the other. Certainly we might like one aspect more than the other. The most important thing before we talk about product, term or permanent, is coming up with the appropriate amount of coverage. So one strategy that I will share that's very unique to special needs is survivorship policies. And I'll come back to the previous slide right now. What a survivorship policy is this is a policy on two lives, so on a husband and wife. And it's not going to be paid out until both individuals pass away. So oftentimes what we'll do from a planning standpoint is I'll have a husband and wife buy term insurance on their lives where each other is the beneficiary. So, you know, if something happens to one or the other, they're taken care of. But then they'll buy their own separate joint survivorship policy. That's really the one that's meant to fund the special needs trust. Because it's on both lives, it's actually a very cost-effective way to address this need versus taking out a permanent insurance policy on just one person If you take it on both, you can actually bring down the cost of that insurance. The other thing is that if one person is not as healthy as the other potentially, and getting that coverage in place is an issue individually, this is also a great way because now we have a pooled health rate. So even though we might have one person that's uninsurable, but another who is insurable, because it's on both, it gives us a better opportunity to get that coverage in place. You know, when you're looking at life insurance, some of the pros and cons, whatever strategy, is that this is more often than not the most effective way of funding a special needs trust because the cost is premium and the death benefit is a lot more and a lot quicker. It's there day one versus us having to accumulate the funds over time, as in the scenario that I described of funding while we're alive. So it's very cost effective. In Texas, it's creditor protected. It creates a large pool of money. And one of the biggest things of this strategy is that it's a tax-free death benefit. So retirement accounts, investment accounts, more often than not, they have a taxable component, especially when they go from one generation to the next. Life insurance is a tax-free lump sum. So that's very, very important because the dollar amount that's there is the dollar amount that's going to be available. Whereas maybe that's not the case with a retirement account or traditional investment account. The downside, I mean, there's an underwriting process, so we have to assess a health rate and we're paying premiums. So to reiterate, you know, we wanted to keep it simple today, but to reiterate in terms of next step, you know, you just got to build a team, a trusted financial professional. Broker Check is an excellent place for you guys to vet your financial professional. Broker Check is a public portal. You just type brokercheck/FINRA in Google and it'll take you to their site. And basically this is a site where you can put anybody's name, anybody's company, their location. You could put my name in there. My first name is Jose, last name Velasco. I go by Miguel. But if you type in Jose Velasco, San Antonio, Texas, I'm going to be the only one that pops up. And it's going to show you my public record of how long I've been practicing, so a little over 9 years, of all my licensing, of any disclosures of any complaints. I have none. Of all the states that I'm licensed and registered. So this is just a great place for you to go see, hey, is the person that I'm visiting with fully licensed, and are they giving me advice that's in my best interest and not just theirs? Special needs planning attorney, critical, and a CPA for the tax component, really, really important as well. So those three professionals, and I know certainly with Catherine and other professionals, we'll work together. This is collaborative. That way we're all speaking the same language and you've got your team and you don't have to be taking too much information from one to the other and back and forth. So I hope that this was helpful. Certainly there'll be opportunities to follow up and ask questions, but also please take down my email and after our presentation, I'm sure Catherine will just disseminate. I'll make myself available and share a link to my calendar, complimentary phone calls. We're here to help and kind of navigate the situation, see if we can help you out in any way. So I certainly appreciate the time and think I'm going to give it back for a few questions now. Thank you.
So the interpreter's asking if you can repeat the website.
Oh, yes. So the website exactly, you know, I think it's brokercheck.org. One moment. Let me confirm that. We get so used to Google sometimes.
Mm-hmm.
But yeah, let me make sure I get that one to you guys.
It doesn't look like we have any other questions at this time, but we'll give them.
So real quick, that website, BrokerCheck all together. So brokercheck.finra.org. One more time, brokercheck.finra.org. Great resource.
Okay. Well, it doesn't look like we have any questions at this time. So I will go ahead and close this out. So I want to thank you, Miguel and Catherine, for your time this morning and for the pertinent information that you shared with us today. If you're in the attendance, you'll get an email with the survey for feedback on this webinar. And it will ask you for future webinar ideas if you have any. This recording will be made available in the next few days, so keep an eye on our YouTube channel and on our website, and we will post future webinars on our Facebook. If you or someone you know would like to speak to a case manager, please call us at the ARC of San Antonio at 210-490-4300 and ask to speak to the case manager of the day. Thank you for joining the ARC of San Antonio today. We hope to see you at our next webinar. Take care and stay safe. Thanks, guys.
Thank you.
Bye.